TDC, a Danish company, was bought by 5 investment funds with residence abroad Denmark. To complete the operation, it was created a corporate structure of 3 companies to be inserted between the funds and the target entity. 2 of the 3 companies in the structure were incorporated in Luxembourg in 2006, and the last one in the chain was a Danish company named Nordic Telephone Company Investment, that in the end directly owned the shares of TDC. Nordic bought roughly 80% of the shares of TDC with resources borrowed from the investment funds. It's worth noting that the funds couldn't apply the EU Interest and Royalty Directive, the Parent Subsidiary Directive, nor the TTA, or double tax agreement with Denmark, given their alien status. It looks like to skip such restrictions, the 2 companies resident in Luxembourg, Angel Lux Common and its holding company, Angel Lux Parent, were imposed in the structure. Subsequently, the rights on the loans were transferred to Angel Lux Common. With such corporate structure, the corresponding EU directives and the DTA between Luxembourg and Denmark could be legally enforced, or at least that was the idea. However, the corresponding tribunal, the High Court of Eastern Denmark, determined that both entities from Luxembourg didn't have any significant administration on the loans. They neither had sufficient assets to demonstrate a proper operation, and they only obtained a modest income, which led the court to conclude that both companies were only conduits inserted in the corporate structure to get a benefit from the EU directives or the DTA between Denmark and Luxembourg. Consequently, the court ruled the companies from Luxembourg were not the beneficial owners of the interests, given that the legal structure was put in place only to get any proper tax benefit. A new tax treaty between France and Belgium has been signed and it is expected to enter into effect next January of 2023. The main aim of the new treaty is to be in accordance with BEPS and the current international standards. The main novelties in the new treaty are as follows. Express reference to residents as subjects of the treaty. Without fulfilling this condition, a taxpayer will not be able to apply the DTA. An exemption to the latter applies to pension funds and CAVs, or collective investment vehicles, on payment of dividends and interests. Partnerships may be considered subjects of the treaty if some requirements are met. Transfer of shares with value, mostly represented by real estate property, will be considered as a transfer of the asset for tax purposes and not a plain transfer of shares. Currently, a transfer of shares is deemed like that, although their value is comprised by real estate property. In consequence, the taxation is in the state of residence of the seller. It's worth noting that Belgium doesn't tax such capital gains. With the new treaty, when 50% or more of the value of the shares is directly or indirectly based on real estate property, the transfer will be taxed in the state where the assets are located, provided that the real estate assets are not used in the business activity of the entity whose shares are transferred. The withholding tax of 15% on the interest payments among residents of France and Belgium will be not in effect any longer with the new treaty. There will be no liability to withhold the tax if the beneficiary owner of the interest is a resident of the other state. In the case of dividend payments, the withholding rate of 15% is reduced to 12.8%, and the reduced rate of 10% is abolished if certain requirements are met by the recipient of the dividend. And the new treaty broadens its scope to wealth taxes, not only to income taxes. These are only some of the new provisions coming in the tax treaty between France and Belgium to enter into force most likely in 2023. Indeed, it's worth carrying out a deep and accurate analysis of the agreement and its protocol to understand the scope of this new DTA. A public consultation in Norway was set out on international reorganizations in the last quarter of 2021. The aim of the consultation was to know the view of the different sectors in the Norwegian community with regard to mergers, demergers, and exchange of shares of international scope. Although the current general rule in Norway is that cross-border reorganizations are basically taxable events, some operations where a reorganization is involved are tax-free, like some mergers, demergers, and exchanges of shares between foreign parties, and also when a Norwegian entity is part of the operation. An important requirement to apply is that states of the parties involved in the corresponding operation apply the principle of tax continuity with the aim to skip schemes of double non-taxation or abusive context. The principle of tax continuity has implied having knowledge of the tax framework of other states, which has been an obstacle to carrying out cross-border reorganizations in an effective manner. That is the reason to propose the removal of such requirement in the Norwegian tax regime on international reorganizations. However, the proposal respects the principle of tax continuity in Norway to apply by all domestic shareholders, those mergers and demergers, as well as assets, rights, and obligations involved, shall be liable to tax in Norway before and after the operation in order to claim the tax-free scheme. I trust these videos help find new ideas to share with other Kreston colleagues and clients in the benefit of all. I am Guillermo Narvaez, Technical Tax Director of the Kreston Global Tax Group, and I'll see you in the next edition. Meanwhile, stay safe.